You all right, Will?
Evening.
Hello. Yes, thanks.
Cool. Let's make a start. Welcome everyone. Usual rules apply. I'm sure you're used to it now. So if you ask any question in the live chat, just make it as if it's about someone else, so you don't put personal data in there. The live chat will disappear once the recording's up, but it will be visible, obviously, to the public whilst this live stream's going out. So other bits and pieces. This isn't legal advice, but we are trying to help out. So we will try to kind of give you some resources and references and stuff when we're saying stuff about these different questions that are going to come in. What else do I normally say at this point? I can't remember. It's hard work. It's been a long few days. It's been all over the place. It's been cool. Anyway, let's get on with it. So we've got a few questions that have come in through the week, and I think a question that we kind of said we were going to answer at the end of last week's session, and I've now forgotten about it, but Shannon raised it a minute ago. So the first question, and Will, I didn't send this through to you, so I apologise for that, but you might know the answer. The question came out the question essentially is a Section 184 letter going to make a decision that someone is not in priority need but is intentionally homeless? And the reason I asked this question is that my understanding, and I can't remember where I heard this, but if you're not in priority needs, then the council's inquiries kind of stop at that point, and so they don't need to make a decision about whether or not you're intentionally homeless. But I might be imagining that. So that's the question, as I say, that kind of rolled over from last week. It's obviously relevant because in one sense, if you it's quite straightforward to make a fresh application if the decision was non-priority, because you just need a change of potentially medical circumstances or something like that. Whereas if it's an intentional homelessness decision, that's you're kind of stuck with that for some time potentially. And so that's why I think the question was based about someone who had quite significant mental health issues, and I think had trashed their property or something. And so the decision was that they weren't in priority need, but they were intentionally homeless, which, as I say, was a problem for triggering a fresh approach. So I don't know. Yeah, as I say, sorry to put you on the spot, but is that a question you know the answer to, Will?
No, I don't. I've never. I mean, there's always been a sort of unwritten rule, as it were, that inquiries are made in that sequence, and that therefore there's no need to think about intentionality until you've considered priority need. Is it that way around? Yeah.
Yeah.
But the actual law says that they have to be satisfied of those things. So presumably, if they did make a decision that said you're in we don't think you're in priority need, and it didn't address intentional homelessness, I don't think you could challenge it on the basis that they hadn't thought about intentional homelessness first. I think they'd say, well, okay, what do you say about priority need? I don't know if anyone thinks I'm wrong on that, but I've never known it come up.
I tempted reading part of the Housing Act. Normally I just stick to the Code of Guidance, I won't lie to you. But there's a section 189B where it talks about an applicant who's homeless and eligible for assistance, and then what they're entitled to, and nowhere in that section does it talk about intentionality. It just talks about sort of like what they're entitled to if they are homeless and eligible, which makes me think that they couldn't come to an intentionally homeless decision, because if they're not in priority need, those aren't the steps in that section to follow. Does that make sense? But that might be if I'm reading it right or wrong.
So that's that's the relief duty section. I never remember. I only remember like a couple of sections, so I don't know. But I think is that 189B is the relief duty, right? So that's going to be the process they've got to follow with anyone who's homeless, or they're satisfied they're homeless and eligible. I don't know. I'd need to read it. I need to kind of just see how it works. I mean, that's an addition to the Housing Act since the Homelessness Reduction Act came in, and for that reason, I don't. Whatever it was, I got told at some point about this kind of sequence. It was before the HRA came in, so I don't think that would potentially address it. But I don't know. I mean, it might be one of those things you just roll on. I mean, so I think going back to that question, I can't remember what the circumstances were, because the way I just explained it, it wouldn't be a problem. You just go back and you challenge the non-priority decision, and you can start again from scratch. But there was a reason why it mattered. I can't remember what the circumstance was. So anyway, yeah, that's that question not dealt with. So we'll go on to the next one. Once it's come in. No, it's just cool. It's just an interesting one, really, from just these kind of obscure situations do sometimes arise. Just a question coming in the live stream, so we'll deal with that. If someone is in emergency or interim accommodation with a baby which is shared bathroom and toilet, and the room is unlivable due to strong unpleasant smell in the room that don't go, what can be done? So I think our bottom line is I think the smell issue, and it depends what that smell is. I mean, if it's a smell that indicates, something unhygienic, something like a rotting flesh smell or a sewage smell, then I think that would indicate you've got something which is something that maintenance needs to get on with. But I guess it just, as I say, it just depends on what that smell. It might be a smell of cannabis or something coming from another flat. In which case, in reality, there's not a whole lot you can do about it unless you want to report people to the authorities, and obviously that can cause issues, which I don't know if it'd be worth the trouble. I don't know. So I think that's, in one sense, plan A is to see if you can get cleaning products, whatever, to do with it. I mean, again, this is when people come home, so they take their Hoover and carpet cleaner with them. But certainly when we worked at Just Us, we had a carpet cleaner specifically for that job. So when people moved into TA and it was rubbish, we just go in there with a carpet cleaner, give that a whiz around, get the Hoover involved, get the bleach out, really. So I don't think, it's not going to be unsuitable on the basis of the smell, unless it was something like a skunk had been there or something and like no one could stand it. I don't know, but that sounds unlikely. But in terms of the issue around being in accommodation with a baby where you've got a shared bathroom and toilet, again, I haven't worked on this sort of case myself, but I do remember Sarah Steinhardt talking about in some training around how that could be an Equality Act issue where, in one sense, practically speaking, how's the mum supposed to actually, kind of look after the baby whilst they're kind of out and about? It might make more sense if there's multiple children. So in one sense, if you've got like a baby and a 5-year-old or something, where's the 5-year-old supposed to go whilst you're in the bathroom having a shower? But again, I've not worked in that particular situation myself, so I haven't seen it in action. But so I don't know if you guys have got anything to add to that or amend to what I've just said.
Shannon? Sorry.
Not really, just that I don't even think you'd need multiple children. Think just a baby, because how's the mother supposed to shower and leave a however old baby by themselves? I think it would still be unsuitable because of the shared sort of resources. I also wonder, I mean, just with the stories we've heard this week and stuff, who else is sharing that with them, and whether there's sort of like issues around safety and risk assessments that have been done, and like there's a lot of things that potentially could be challenged. I think it doesn't sound like it's suitable at all, but go on, Will.
Well, just to go back to my usual theme, that if it's shared bathroom and toilet and it's not owned by the council, then it's bed and breakfast, counts as bed and breakfast, and they can. It does refer to it being emergency accommodation. So if it is a genuine emergency, then it's lawful for 6 weeks. So after 6 weeks, that would be unlawful, unsuitable accommodation. The other thing, and I know it probably sounds, people may say, well, that's a bit over the top, but I always think if there's a child living in unsuitable accommodation, then it is worth getting children's services involved. Because if a parent was to put the child in that situation of their own accord, they might find that they will getting children's services might become involved. But if the child, it's a question of deciding what the impact on the child is, and if the well-being or development of the child is impaired because of that situation, and the child is in need. And although children's services often have to be sort of dragged kicking and screaming into this type of situation, I think they have a clear duty to assess and protect the interests of the child there. So those are the two things I think. One is look at whether it's a genuine emergency, and if so, have 6 weeks run out, and then you could challenge it on the basis that it's not. It's bed and breakfast and it's unsuitable for family with children. And secondly, try getting children's services involved. Yeah,
cool. I might just make this a bit of homework for myself and go back to the training I've had before about this, because The argument may have also been around, kind of post-birth health issues that mothers often have, and kind of, how, having a shared bathroom, that situation where you might have, kind of medical treatment ongoing and things like that, you need to deal with it. But as I say, so my best answer is just I might go away and just see if I can find out the bit that I specifically heard about it. But yeah, hopefully just what we covered there will be useful, if nothing else. Again, in terms of getting help cleaning out accommodation, it's something which you may get lucky with local charity. And again, I've told this story probably multiple times here. It's not something that would be directly relevant here because it's a smell rather than the way it looks. I worked with a mum and baby in this situation who were put in temporary accommodation. It was very unclean. They raised an issue about it. Nothing happened, but then they put a video of it on YouTube and just said to the council, if you don't sort this out pronto, we're going to just put this into the We Are Bedford group or whatever. And lo and behold, they were immediately put into a hotel for a couple of nights whilst the property was cleaned. But as I say, if it's a smell, obviously you can't convey that in a video, so it's not going to be particularly helpful. But yeah, as I say, I'm going to do a bit of homework on that to see if I can come out with anything else that we missed today. But that's hopefully, as I say, better than nothing in the way things work. Another question is coming on the live chat just about someone who's basically been living in Ireland. They returned to, I'm assuming England here or the UK recently. Essentially, can they make a homeless application on arrival? So I guess it's a question about, first of all, about eligibility. And my understanding is that, so because Ireland's in the common travel area, the habitual residence test doesn't really kick in. It's, if you're in the common travel area, then you don't need to pass the HRT. You're just immediately eligible for the help you can get. Obviously, you then go through the homeless application process. So you would need to look at, why did you leave your last accommodation? Are you in priority need and so on? But there's mention there about, sounds like pretty significant medical issues. So you'd have thought you'd be in priority needs. But as I say, the question of intentional homelessness may be a bit trickier. If the accommodation you've left was suitable, was available for your occupation, and was reasonable to continue to occupy, then you might end up getting an intentional decision. But again, eligibility is not in any way my strong suit. So I don't know if you guys have got anything to change about that, if I'm wrong, or add to that.
I thought, and I'm weak on this area, but I thought as well, because it's a common travel area, and if you've lived in the UK sort of before, for a settled amount of time before coming back, it actually doesn't matter how long you didn't live here, because you did live here for a settled amount of time anyway. So they might not even have to do the habitual residencies test, but even then, I think it's all about intentions. With intentionality decisions, I wonder, if their current accommodation is unsuitable because they can't access the right healthcare. It's probably a stretch, but
I guess I don't know what. I guess it depends on what medical treatment can you get in the UK, which you can't get in Ireland. I'd have thought it'd be pretty equivalent. And I've never lived in Ireland, so I don't know. But is there any kind of cost to the health service in Ireland that would? There is one. Okay, so you might be in a situation where, in effect, you can get treatment for free in the UK that you can't get in Ireland. I don't know. Yeah, I think so. Yeah, that's an interesting question though. Could you leave accommodation because you can't get health treatment there and come? I don't know. It seems like the sort of thing the HRT. I know the HRT probably doesn't kick in here, but it seems like the sort of thing eligibility is designed to kind of to eke out. So I don't know. Again, this might be something we've got to roll on until next week to get a definite answer. And it might also be a good one for the Facebook group, because I think you would then get potentially 20 people being able to answer rather than just 3. So yeah, but as I say, my understanding is common travel area, you don't need to, you're eligible. Basically, you're eligible for housing assistance under the Housing Act straight away. So that's not the problem. The problem is going to come with potentially intentional homelessness, or even it might be a not homeless decision. Unless you kind of wrapped up that last accommodation by ending the tenancy or something, then that could also be an issue for you. So yeah, again, we'll make a note of that, roll it over and see if we can get a definite answer, certainly from the Facebook group, if nothing else. So yeah, we're not doing so well so far. We're getting there though. Hopefully it's at least some use in terms of what we're covering. Next question we got, family with one parent with mental health. So I'm guessing it's the parent who's got mental health issues, and 2 disabled children. should the council do a care plan for them? We might need a bit more context with this question. My guess here is that it's in relation to a homelessness application. And my guess when you're talking about care plan, I don't know if you're talking here about the Care Act itself or whether you're talking about personalised housing plan. I mean, I think the answer is yes for either way, whether it's when it comes to disabilities, I'm going to guess, yeah, that the PHP would kick in if you satisfy the prevention or relief duties. And under the Care Act or Children Act, I'm going to guess you get something equivalent to a Care Act assessment and plan. I've never worked really within the Children Act. So I think the answer is yes, but I'm not quite sure, as I say, without seeing more context to give you a better answer on that. And I appreciate there's a 30-second delay here, so it might be, it's going to take a little bit of time for you to give us a bit more context on that. So yeah, anything else on that one, guys? As I say, or any understanding of what that might be about?
Just a reminder that a disabled child is automatically in need for purposes of the Children Act 1989, and so would be entitled to a plan to meet their need if they present to children's services. I'm not sure, but as you say, the question's a bit unclear as to whether it's one of two parents has mental health problems, or the only parent has mental health problems, which may mean that they might not be treated as having capacity to make a homelessness application, in which case, well, they could do it with a deputy from the Court of Protection, but the other route would be through adult social services, through the Care Act.
Something on mental capacity to make a homelessness application, which is something we visited several times before. There was a helpful LGO decision either last week or the week before, and the good thing about LGO decisions is they give the law. And there was a case involving mental capacity to make a homeless application. They basically, the LGO spelled out that when we're talking about mental capacity, you don't need to know the ins and outs of the tenancy. You just need to have a general understanding in order to be assessed as having capacity. So I know we talked before about, who actually understands the intricacies of a legal or the legal requirements of a tenancy, but the LGO decision would suggest it's really just about understanding you need to pay rent. You can choose where you want to live. If you don't pay rent, you can get evicted and so on. It's not in any way the technicalities of it. So I would imagine, most people with mental health issues will certainly have mental capacity to make a homeless application. But as I say, we might just need a bit more information just from that question to be able to answer it properly. And just also going back to the question around Ireland and the common travel area, you can the final few pages of the Homelessness Code of Guidance is specifically about the habitual residency test. And I would imagine that the common travel area is mentioned within that, so you might be able to get also a much clearer understanding from it than we're able to give. If you just look in that, as I say, it's like Annex 1, and there's only one annex in that, the Code of Guidance. So just have a look at there to see if it's clear on the issue. Okay, cool. Next question, and it's a multi-comment one, so just bear with me while I try and read it out. So my question is, if I've left my social housing property due to domestic violence and I approach another borough, can you only offer me private rented? So a bit more context, I'm fleeing Lewisham and approaching Greenwich, and they say they won't rehouse me, but have put me in temporary housing. They've asked me to look for private rent, and I'm a care leaver, and I have I have 1-year-old son, but I did already get my settled flat, but I'm now fleeing domestic abuse. So, right, there's a good question. Obviously, quite a few things going on here. So, first things first. Just because just before we even get to the issue of domestic abuse, if you make a homelessness application and the council owe you a full duty with domestic abuse, they're likely to, because that's just the way the law works with it. That does not guarantee that you're going to have social housing at the end of it. They can either discharge their duty into social housing, or they can discharge their duty into a suitable private rented tenancy, which has to be minimum of 12 months if they're going to do the full duty. However, so that's main housing duty. It gets more complicated because in the relief duty, the council can also end their duty by giving you what's called a final Part 6 offer or a final accommodation offer, and they are sort of similar to the main housing duty, but they're not as good. So, if, for example, the final accommodation offer, it would only need to be a 6-month offer of accommodation. So, councils are at liberty to do that. It's a real real issue where, as with this person, we're talking about someone who's got social housing, which is a really good thing because it's far cheaper, far better security of tenure, and because of domestic abuse, they end up with private rented as their only option. But what I would say is that Greenwich can't. I don't think there's anything that Greenwich can say to say, oh, you definitely won't get social housing. It's just it's basically it might be a high risk that you don't get social housing, which isn't quite the same thing. So hopefully that deals with a bit of it. So sadly, if you're fleeing abuse, that might be the result is you end up in far inferior accommodation. In terms of the additional kind of care or support needs that are going on here, the council should have done first of all a housing assessment with you, but also a personalised housing plan. And in that, they should have identified these kind of issues, because these issues are very much relevant to kind of the support they're supposed to give under the Homelessness Reduction Act. And they should have kind of, they identified that actually they need to be particularly, clear and careful and give very good advice and support around these kind of these decisions that you need to make. So yeah, I don't know. Yeah, that's kind of my first phase of an answer. What else do you guys think on this one?
Shall I jump in? I mean, I think this question sort of highlights the single biggest problem I've got in my work at the moment, which is having to advise people who are homeless at home from social housing that they are not entitled to alternative social housing. And this is an example would be where somebody's fleeing domestic violence. And you'd say, well, it seems that what Greenwich have said here, presumably rehousing means provide me with alternative social housing, because they have rehoused in the sense they provided temporary housing, which is the source of rehousing. It's just not long term. I think there are possibilities, but at the end of the day, this is a resources issue rather than a legal issue, I think, because no amount of lawyers pulling out sort of obscure sections of the statutes or codes of guidance or policies is going to produce social housing stock that is available for that person. And that's the difficulty. Although, I mentioned last week, I think, that I was watching the Doughty Street webinar on domestic abuse, and there was a very good presentation. I forget who it was who gave it, but she went through the possibilities of challenging management transfer failures. And it's very common for housing practitioners to sort of not really focus on management transfers and just say, oh, well, the problem is they say they haven't got anything and we can't do anything. But she was saying on the webinar that local social landlords have sort of reciprocal arrangements with other organisations, and that's worth pressing. And I've got one at the moment where, in fact, it involves somebody who's fleeing Lewisham, and they have applied to Lewisham. They're fleeing a housing association property in Lewisham. The housing association property are saying, sorry, we haven't got anything. And Lewisham are trying to find somewhere suitable. But the solicitor at Lewisham, who I guess I'm quite well with, was saying to me that something really needs to be done about the housing association, because you can't just say, sorry, we haven't got anything, because there's all these possibilities of finding things through other organisations. And I've got to find the time. I've got to do some research and listen to this webinar again, and then dig out what it is I can ask. Because it should be that you can ask social landlords, show us your policies for reciprocal arrangements and what arrangements you have in place. And probably the housing officer has not utilised those. So it's worth looking into, but it's pretty obscure stuff, I'm afraid, at the moment. But I'm afraid that the problem is, if you've got to take the choice so often. I mean, overcrowding is the other problem. I mean, if the council say, yes, you're horribly overcrowded, we accept you're homeless, but we're not going to give you another council tenancy necessarily, because that's a Part 6 decision. Yeah, those are my thoughts. I'm sorry that they're not particularly inspiring or helpful. But it's ultimately going to come down to just providing more accommodation and building more housing.
I was gonna say about sort of managed. We could in Bedford anyway. They're called like managed moves with the main housing association, and I think it works fairly well here. But again, it's quite a large housing association, and there's different areas. And I think particularly with domestic abuse as well, you know, it's not necessarily the relationship that the housing association has with other housing associations, but potentially in their own area, because you know, not every domestic abuse survivor has to move the 50 miles, the 100 miles, whatever it might be. Sometimes they can move in the same area, just a little bit. But you're right, the stock isn't there. And actually, it might be one of the instance where, you know, approaching your housing association first and saying, look, this is my situation. I need this to be discreet. I need to, you know, do this, what have you. It needs to be right. Can you support me with this? I know, again, certainly in this area, we're quite lucky with housing associations having sort of like specified workers for these situations. But even then, I know there is issues locally and much wider.
I mean, presumably the webinar you just mentioned would be very interesting for housing officers, because in one sense that if they knew the intricacies of those kind of management transfer stuff, they could be the ones challenging housing associations to find alternatives to temporary accommodation.
Yeah.
So
that's what Lewisham was sort of saying to me off, you know, on the phone. Rather, they probably wouldn't put it in writing because it's sort of bad manners to that. But the I will pledge now to try and do it. I put some time aside. The problem is the webinar is 5 hours long. So I managed to, I had to do a trip to the airport and drove for an hour and a half listening to the first part of it. And I want to go through it again and sort of make notes. So I'll try and do that over the next couple of weeks and report back, and I'll maybe do a blog post or something that's we can highlight it.
Cool.
Yeah, it would be really good to look into that.
I mean, something else just that might kind of kick in with this individual. They mentioned their care leaver. It depends how old they are, obviously, but if this is like a 19-year-old care leaver or something, there would potentially be support still available through children's services, like leaving and aftercare stuff. Obviously, once you hit, I don't even know what the ages are in terms of the when that ends, but that is possible that might help. And then there's just a further comment from that person just talking about, you know, the fact they don't have a very proactive housing officer. You know, that's something you can do in terms of chasing them, and if they don't respond at all, you know, to important things, then you can, you know, raise it, potentially escalate it within the organisation. But it does feel increasingly, you know, bleak in terms of what people can actually do in London, other than just wait years, which is not the answer anyone wants. And I'll say, for anyone who's not homeless listening to this, you need to be putting your own local authority, you know, holding it to account. Really, there's a whole bunch of stuff that anyone can do, lay people can do. And it's no good for us people who aren't homeless to say, oh, you know, well, there's just not enough housing. We need to be actually, you know, specifically working with other members of the public, whatever, to actually push this issue up the hierarchy of issues that councils face and the government's facing, because the damage this is doing to the nation is pretty ridiculous, to be honest. Okay, so again, not great news, but hopefully that still gives a bit of clarity around that. Next question, unless I've missed something. So, is leaving your property after Section 21, and basically went to live with a friend, eventually went to council, considered intentionally homeless? We might need a little bit more detail about this, because it might just depend on the kind of the time scale of it. But if your Section 21 notice has expired, then you know, the code of guidance says it's not reasonable to remain there after that point. And so I guess, you know, in one sense, if you just basically left without a fuss, and then moved in with someone who's just sofa surfing or whatever, then I don't see why you'd be found intentionally homeless. But it would be a bit different if, for example, you'd gone to a council earlier on and the council said, don't leave, you know, you'd stay there until the eviction date or something, and then you left anyway. That could become a little bit more problematic. So yeah, and again, we're assuming here that when you moved in with a friend, it was just sofa surfing. It wasn't like you had a room with a friend and you were paying rent or something, and it might be considered to be settled accommodation. So yeah, I don't know what yeah, is there anything else that we need to know in order to answer that question?
I think I mean, the point you made is whether they've been advised about it, and I suppose the question is whether it's a valid Section 21 notice. If it's a Section 21 notice which is clearly invalid, but you've got to be pretty up on your housing law to spot that. And I may be making a mistake here, but I'd have thought that if the landlord served a Section 21 notice on you, it might be possible to argue you're not intentionally homeless because the accommodation wasn't going to remain available for you, because it was inevitable that if they, well, unless, of course, the landlord, another scenario is the landlord may have said, forget about the Section 21 notice, you can stay there if you like, which would mean that this moving out after the Section 21 notice would still give rise to intentional homelessness if it had been withdrawn. Or, but it does seem very harsh that if the person moved out in good faith, thinking that they had to leave because they've had a Section 21 notice and there was no reason to think it was invalid or withdrawn, I think they'd have a good chance of challenging that.
Yes,
think-
certainly. Sorry, Shannon.
No, I've just seen another couple of comments about how they left the day of the Section 21 that finished and went to live with a friend. Like, before I knew anything about sort of the homelessness sector or housing law or anything like that, I think that's probably what I would have done. You know, if I would have taken a Section 21 at its sort of word, I would have said, right, that's the end date. I wouldn't have, I would have panicked about bailiffs and whatever, but I would have just left on that day, because I'm like, right, that's when my tenancy ends. And I would have gone and lived with a friend. Like, I think it's almost, you know, I can't think of the word it's used now, good faith sort of, you know, they've just gone and it's not,
Yeah, so if you search for the term good faith within the Homelessness Code of Guidance, if you Google Homelessness Code of Guidance, get the PDF, search for the term good faith, it crops up in the intentional homelessness chapter quite a lot. And basically, I'm reading, there's a few bits that apply here, but I'm just reading from 9.23. So acts or omissions made by the applicant in good faith where they were genuinely unaware of a relevant fact must not be regarded as deliberate. So the fact that they didn't go to the council like early on, or the fact that they just, you know, took the Section 21 at its word, potentially would be something which you get protection from this. Provided that the applicant has acted in good faith, there is no requirement that the ignorance of the relevant fact was reasonable. So, you know, you will often get that approach if you go to a council. They said, well, why didn't you stay put? Why didn't you come to us earlier? And those things aren't things that would mean that you're intentionally homeless. You know, the question, you know, as I say, as Shannon just said, you know, the question is, you know, would a reasonable person who wasn't up on housing law, you know, would that be a reasonable thing for them to do? Well, yes. And as I say, if as it goes on to say, you know, there's no requirement that the ignorance of the relevant fact was reasonable if they were to act in, or were shown to act in good faith. So I think what we're looking at here is, you know, what the council will be looking at, we're talking to the landlords, what conversations were had between the landlord and the applicant. And as Will says, you know, that you know, landlords do sort of shady deals with tenants and kind of, you know, say things that they're not going to put in writing, and that stuff can be taken into account. So as Will said, if the landlord had actually told the tenant, oh, you know, you don't really need to leave, it's all right, I'm just going to forget about it, and then you left anyway, then you're in trouble. So that, I think that's kind of stuff. As I say, there's more. I'm just trying to see if there's actually, because they give some examples. Yeah, here we go. Yeah, look at this, 9.24. A general example of an act made in good faith would be a situation where someone gave up possession of accommodation in the belief that they had no legal right to continue to occupy the accommodation, and therefore it would not have been reasonable for them to continue to occupy it. This could apply where someone leaves rented accommodation in the private sector, having received a valid notice to quit or notice that the assured short-hold tenancy had come to an end, and the landlord requires possession of the property, and the former tenant was genuinely unaware that they had a right to remain until the court granted an order for possession and a warrant or writ for possession to enforce it. So if that applies, you should be all right, basically. Again, so it's 9.24 of the Code of Guidance. There's even more stuff in there, but I think we'll kind of leave it at that, but hopefully that answers it. Again, apologies if I've missed anything, because we've got a whole load of comments coming in thick and fast. And so it just says, after leaving the property for a month, we're currently in a hotel with 3 children, or 7 weeks. So I'm not quite following this, but hopefully I'm doing it justice. They said that I had to look for private rent and bids. I approached the council when I received this. So I approached the council when I received the Section 21. well, then it's going to depend on what advice the council gave you, because generally speaking, the council will advise you to stay put. And if they can prove that they gave you that advice and you didn't, if you disregarded it, then you're in a bit of a sticky situation. It does, as well. You've got the fact that you're bidding, so that says to me you're on the housing register, maybe under Part 6 rather than having made a homeless application. And also, being told that you need to look for private rented is absolutely standard. So that's not, in one sense, that doesn't mean anything. If you go to a council and say you're homeless, they'll say, well, look for private rented. They might also say, if they're useful, they'll say, well, we can help you with money to get into private rented if you find somewhere, because everyone wins. But I think that's that comment there about I approached the council when I received the Section 21. That would be a few alarm bells there, because I'd be like, as I say, this would be their bread and butter. They would probably have advised you to stay put. And if you then disregarded it, there's going to be potentially some issues for you, and it's going to be, all gone, Shannon.
But even if they are intentionally homeless, because it said 3 boys, I'm assuming children, not adults, then they'd be eligible under sort of the Children's Act, wouldn't they? So they'd still get housing. It would just be in a roundabout different way.
Even worse housing. They're still being priority need. They can still make a homeless application. They should still be put in interim accommodation. And even if the council was to make an intentional homelessness decision, they've still got to house them for a period of time that gives them a reasonable opportunity to find something else. So that is, if nothing else, that's 3 months in accommodation, but very far from ideal. Okay. Again, just going back through, because I think I missed some here. So this is in relation to the question about the care plan. So the council said they don't need to do a care plan. Only one parent has mental health issues and both children have their own needs, and they have been let down by their homeless officer. Also, the housing team won't reply to any of their emails, and they're not feeling supported. They're just waiting on the courts to grant possession back to the landlord. So I think it does seem to me that we're talking about personalised housing plans. I think. No.
So I would have assumed that they're talking about a mental health care plan. So that's
okay.
When I hear the word care plan, I immediately think mental health care plan, and then I think the early help care plan. So I would assume, but often it's the community sort of mental health team that does those care plans. So the council could be right if it's a mental health care plan, because potentially you might have a mental health issue, but you don't need a referral into sort of community mental health services, and you don't need that that can happen. But I'm not sure if I'm reading it right.
But the housing team would still need to do a personalised housing plan, and the mental health care plan would kind of deal with the parents, in theory, deal with the parents' mental health issues. There would still need to be a personalised housing plan, which would assess the needs of every household member. And given that we've got 3 household members here who've got significant issues, then they should need to be very careful. I mean, at least 2 of these individuals have got a disability, so they need to be super careful about how they assess those family members' needs, and need to come up with a reasonable plan. Again, it comes back to stuff we've said before. When you're doing personalised housing plans, particularly when there are significant issues like this, you need to be spelling out to the council what it is you need from them, and what it is you need them to do. So I said to Shannon earlier, I've got an LGO complaint came back that I'm involved with today, and there was a section of it which was not upheld, because although we raised the fact the family had disabilities, we didn't in writing say that they needed a particular adjustment being made. And so my learning lesson for there is, when you're raising disability issues, you need to very clearly state what reasonable adjustments the person thinks they need in order to kind of respond to those needs. So,
is the duty not on the local authority there, though?
Well, so I'll show you the decision.
Sorry, that's a tangent. Sorry.
Yeah. So I think I'm not going to argue it. I've learned my hard way not to argue with the LGO when they send like a draft decision. But I'm not satisfied with it. I think it was on the council to make inquiries, and the decision is basically stated the council can produce anything which showed that they had actually considered the family's needs. But anyway, as a support worker, that's what I learned. If you're gonna work with people in your own referral and an assessment process. You need to be picking up on people's disabilities, and then you need to specifically ask them what do you need the council to do in order to. It might be obvious. It might be they need wheelchair user friendly accommodation, or it might be something a bit more subtle. But anyway, you need to spell it out. So and again, for this, this person, then the housing team won't reply to emails. So I think as well as chasing the council, see if might be the mental health worker can get involved and kind of chase response as well. If you've got children with disabilities, as Will said, they're automatically a child in need. So a children's services involved, can they be getting spurring the housing team into actually producing some sort of information that will put your mind at ease a bit, even if it's not a good answer. It's still better to know, I think, if to deal with the uncertainty. Okay, so just a comment there. I think I kind of feel similarly kind of just despondent about the sector right now. So this person just saying that the homeless application process, by the sound of things, has destroyed their life. There's no help, no support, nothing. You're on your own in the world. Abandon all hope. Yeah, I hope it's not that bad. But I think people going through this situation, it's horrendous. And again, all I see is professionals just shrugging and waving their hands and saying, "Oh, there's nothing else we can do." There's loads we can do as workers to rattle cages and to raise issues really robustly. Personally, I'd say if you work in the homeless sector and you haven't got a very clear plan of what you're doing to, increase housing stock, increase quality of service from the local council, then you're not trying your hardest. You should be doing more. That's the way I feel about it. As I say, in Bedford, we've seen loads. You can do loads of good stuff very easily with minimal time. You just need to be, willing to try, really. So I feel for that person just saying that. Sounds like you're in a tough spot. Okay, so just making sure I haven't missed anything. So the next person, so I've been granted a court date for my defence claim of extreme hardship. I've submitted it late after a possession order was granted in my absence. Will the new court date put on hold the bailiff order? Right, I don't know the answer to this, very simply. So my understanding, I'd say what I do think I do know. So when you get a possession order going to court, you can basically ask for an extension on the kind of the time you can remain there. I think, if I understand it, it's not a very long extension. It's only by a few weeks. That's what I think we're talking about here. But Will, you might correct me.
Yeah.
So yeah. What else do you do? I mean, you probably know more than I do about this. What we need is
I think what this person's talking about is a slightly different situation. What you're talking about is, I think, if you get a claim for possession made against you and you haven't got a defence, you can ask for up to 6 weeks before it takes effect. I think that's the maximum the court can give. So they say possession in 42 days. But this is a situation where somebody hasn't put in a defence to a claim for possession, and a possession order has been made in their absence, and they say they've got a court date. But I'm guessing here, but I'm guessing what they've done is they've applied to set aside the possession order, because they've said to the court, "Hey, I wasn't there. This isn't fair. Can I have? Can you set it aside?" So what's possibly happened is, if they filled in an application notice to court, the court said, "Okay, we'll list your application for hearing on X date." And then, so that means the answer to your question of whether that will stop the bailiff's warrant is not necessarily, because what you have to do is apply for an order to set aside the possession order, and also to stay the enforcement of the possession order pending the outcome of the hearing. It may sound a bit sort of ridiculous, because you think, well, why would they let them enforce it if they've set a hearing date? But it may be that when it comes to the hearing date, the court will say, "Well, you haven't got a leg to stand on because you haven't really got a defence." But say I had one the other week where somebody had a possession order made against them whilst they were detained in a mental hospital, and it was set aside straight away. I mean, we didn't get to the stage. We kept waiting for them to issue a warrant, but I knew that if they issued a warrant before we got the hearing of the application to set aside, I'd have to make a new application to stop the warrant being enforced. So my advice to this person is, don't assume that. It's best to make a second application if necessary to stay the enforcement of the order pending the outcome of the hearing to set it aside. Because if you've got a good argument for setting aside the order, it would be a great injustice if you were evicted before that could be considered.
I'm glad you're here, Will. I don't think I've ever heard so much jargon used within like a 2-minute section. Like, I mean, we need to do a video about exploring this stuff, because I'm like,
I'm sorry about it. I thought I was
no. It's not you.
I didn't use any acronyms or anything, did I?
No. This is like how it's just, as I say, for someone who does, this isn't, you know, like the work I've done tends to be like after all this happens, I'm befuzzled. But yeah, I think we need to kind of do a video on that later on or something. But anyway,
welcome to my world.
Yeah. Okay. Yeah. I mean, hopefully that made sense to the person. So what you're saying is, don't, you know, make a second application. You know, don't kind of not do that on the basis it might not have been done already. Is that right? Is that what you just said?
Yeah, because if there is, and it sounds bad, let me just get that right, because it says, will it stop the hang on, will it put a hold on a bailiff order? So if there's I mean, when by a bailiff order you mean an eviction appointment, I think, or a warrant for possession is what it's known as. So if that's been issued, then no, it won't. So you better get in there and apply to stop it. But if no order's been made yet, then you may get away with getting your hearing before the bailiffs make an appointment.
Yeah, and I guess, I mean, this is a generic point that we kind of make whenever we mention this sort of thing. If you can get along to the court dates, then do so. There'll be a duty solicitor there, and you know, as I say, I've only done it once with someone, and it was really effective just turning up. In fact, I turned up, completely changed things, and she didn't get evicted for months because we just provided some information that they wouldn't have otherwise had. So yeah, and my experience of it wasn't intimidating. It was not like, you know, a courtroom drama or anything. It was really kind of low key, surprisingly low key actually. Other than the security guard on the front desk, it was very, very relaxed. So yeah, okay. So right. So let me check. I've missed one. So okay, I think the next question is: a friend is going through a homeless process. 17 years old, they've had a meeting to discuss options, section 17 or 20, or a homeless application. Is there a benefit to any option? It's a really good question. So essentially, section 17 and section 20 are we talking here about the Children Act, and obviously homeless applications is section 184 of the Housing Act. So for a 16 and 17-year-old, you will automatically be in priority need, but there's a requirement that you need to have been through, or you need to have had a Children Act assessment done and effectively declined that support. So it's an option. You know, you can, you know, a young person could refuse the support available through the Children Act and elect to make a homeless application, and they'll automatically be in priority need. You know, the textbook answer is you're better off under the Children Act, because Children's Services will not only have a duty to find you accommodation, but they'll also have a duty to provide ongoing support. I know that's not the terms they use, but that's kind of what I would see it as. And also, you wouldn't have any issue there about intentionality, because let's say it's unlikely, but I guess technically speaking, you could have an intentionally homeless 17-year-old. Say they were being in the YMCA and they got evicted from the YMCA for, you know, misbehaviour or whatever. Then potentially, if you went down the homeless route under the Housing Act, you might have a situation where, although you're in priority needs, the council won't have a long-term duty to you because you're intentionally homeless. So they'd only have that short-term housing duty to you. Whereas, you know, children, and I would say that, yeah, the reason people do sometimes elect to decline this children's support stuff is that they don't want the social worker. They've had enough of them. They just want to be on their own and kind of just get on in the world. So what should be possible is you should be able to get all of that information before you make the homeless application. So you should be able to approach Housing Options and say, this is my situation. I'm going to Children's Services for this thing, but should I come to Housing Options, what are you likely to do with me? And they're going to be as unappealing as possible. They're going to make out like it's, you know, they're not going to do anything probably. But if you get it to give you in writing, they should be able to give you like some permutations of what might happen. In some areas of the country, you may well end up in a good place. In London, it sounds like you probably don't want to be going down the homeless route. I would hope that the Children's Service route is going to be better than the homeless route, but who knows? I know some people who use children's services in London, and it seemed to be okay. You know, are there to kind of kick and scream, there to dig their heels in and ask for stuff in writing a lot, just to make sure the social worker was doing the right thing. But it was a much better result. So yeah, I think that's my answer. Again, fill anything I've missed, guys, or you know, correct me if I'm wrong.
Well, I think it's definitely going to depend on sort of the person's, like say, the relationship with the social worker, with children's services in general, their whole experience of that world. Because like you say, having that fresh start or what have you. But I've also, from sort of people I've been talking to and what have you, I know it's quite common for children's services to want to put in sort of 17-year-olds in particular, you know, into youth supported accommodation, so like young people's hostels and whatnot. So I do wonder whether and I mean, look, housing options are definitely, you know, gonna try and get them into supported accommodation as well, because we see that all the time, no matter who you are. But if that's not something the person wants, I would probably say that they actually have more choice under housing options for their own sort of accommodation rather than supported accommodation. Because with the children's, you know, if you've got a social worker saying that, you know, you need supported accommodation, as a young person to sort of challenge that and to fight that, you're not in a very good sort of situation. Whereas if you were to move away from that system and go into, I don't know, it swings and roundabouts, and it's going to depend on the relationship and what that person needs and wants, essentially.
And I think it's worth, yeah, exactly. And I think it's worth kind of bearing in mind that you know, the supported accommodation route is a good example. That is an option where there is a reasonably high risk of you becoming intentionally homeless, because, you know, well, I've worked in those kind of environments. It didn't seem like people were having a good time there, to be honest, who were staying there. You know, there's lots of antisocial stuff going on. Yes, people did get their heads down and do their time and get out of it. But you know, equally, the rules are pretty strict, and people were getting evicted for relatively low-level things. And so the problem with going down the supported accommodation route rather, you know, than other routes is that you run this risk of being intentionally homeless. It's far easier to become intentionally homeless from that type of accommodation rather than, you know, from your own accommodation. But again, you know, I can't imagine being a 16 or 17-year-old in a traditional homeless hostel. I mean, I'm pretty sure there's stuff within the Code of Guidance which says that young people should not be put in B&Bs. I think it does say that a 16 and 17-year-old should not be housed in B&Bs as part of the temporary accommodation. But you know, ultimately, housing's duty is to provide you with 4 walls and a roof. It's not to provide that additional stuff that children's services might be able to. I mean, it's a really good question. I think for us to see if there's a way of exploring it with people who work in the sector. I can think of some really good social workers who I would trust to do a really good job with. And as we all kind of know, some of the social workers are pretty battle weary and not very helpful. So, yeah, it's a good question. I hope that's helpful. I think, yeah, if I think the key thing for someone in that situation is to work out how they get unbiased advice from someone who knows them. Because children's services have got an agenda. You know, if you tell them you don't want their support, they'll be like, great, see you later. And equally, housing have got an agenda. You know, great, you don't want housing, you go back to children's services. So I think those things can all kick in, if that makes sense. Okay, where are we up to? Struth. So, oh, well, this is a positive one here. So, local council constantly lied to me, saying there was a 7-year wait for council housing. With the help of your videos and other things, I got housed within 1 month of my Section 21 leave date. That's good to hear. Outside of London, that's not unusual. You know, we see people getting housed in very short spaces of time. And you know, and we said last week about the average waits of these different areas varies massively, ranging from, you know, 10 years in London through to, you know, less than a year in elsewhere in the country. So I'm really glad to hear that. I'm glad this stuff's useful. It clarifies it's a council flat. So yeah, we see it. You know, that's why we kind of bang the drum about making homeless applications. Partly because we don't do most of our work in London, so it's less depressing, but also because outside of London, a lot of people get housed, you know, in decent quality accommodation, and they don't become homeless ever again. So yeah, far better in that sense than private rented accommodation. So yeah, no, happy to hear that's been a good outcome for you. Wish you the best. Just on that kind of note, just bear in mind that there will probably be local organisations that can help you with kind of furnishing the flat and that sort of thing. So as an example, this won't necessarily be true everywhere, but in Bedford, we've got local Emmaus, which is like a homeless charity, and they'll give you like a £250 voucher to spend in their shop, which goes a long way in their shop. You actually get some pretty decent quality stuff. So things like sofas, beds, that sort of thing, fridges, washing machines. But I'm sure in most areas there's probably something you can access. There'll certainly be like a welfare provision grant or something similar in the local council, which is maybe worth a couple of £100. So there are things that you can be doing, or things you can get to kind of make that place into your home. Carpets is the difficult one in my experience. Trying to get flooring is quite hard, but certainly there are grants for other things. I'm not quite sure where you'd find out about that locally. You might actually be best to, if there are any kind of sort of generic homeless services like a day centre, is ring them up, because they might know about them. You don't have to go to the day centre, but you can ring them up and see if they're aware of any schemes that might help. Cool. Just let me know if I missed anyone, guys, because there's obviously a lot of comments here, just trying to keep track of it all. Yeah, and just someone making a point that there's loads of empty flats. Yeah, the stats are pretty astonishing, really, with the number of empty homes in the UK. It's like there's hundreds of thousands. They're just not in London, basically. Right, so unless I've missed something, I think the next question is, and bearing in mind, I've just seen the time, guys, so we're probably just getting there. Basically, we'll probably be able to deal with the following questions. So someone's received an application form from court to fill and send back, but they didn't return the form. What happens if they don't attend the court? So again, I think this is one for you, Will. Unless
They've
Shannon,
commented saying it was they've just added a comment saying application form for section 21, just to clarify if that makes a difference.
Okay.
Yeah. Okay, Will, so stand by for some more jargon then.
Yeah, cool. We're ready.
So section 21, a short-hold tenancy, accelerated possession procedure is the first bit of jargon. So the courts have developed a thing called the accelerated possession procedure for section 21 cases, because often there will be no defence, because if the landlord has served a valid section 21 notice and it's in a short-hold tenancy, the court has to, in theory, has to make a possession order. And so if your defence is, no disrespect to anybody, but sort of, I've got human rights or I've got children, the judge can say to you, look, sorry, you're breaking my heart, but I can't do anything. I've got no power to stop this. So the purpose of putting in putting in a written response to that application is really important, because if you don't do it, you'll get a possession order fast, because it's the accelerated possession procedure. They give you 14 days, I think, from the date when you get the order, when you get the application, or to put in a response. And if you don't, it'll get put on the judge's desk and they'll make a possession order without a hearing. That's the key characteristic of the accelerated possession process. There is no hearing unless you put something in which makes a judge think, yeah, we need to have a hearing about this. So I hope that answers the question. So what will happen is you'll probably get a possession order, or almost certainly will, if the landlord's gone to the trouble of issuing the claim. Can I just answer one other question which we just missed about court procedures? There was a question about how long does it take to get a bailiff's warrant after you get a possession order? And the answer to that is, if the landlord does everything they should do as quickly as they should do, I would say, well, it varies from court to court, but I would say probably somewhere between 4 and 8 weeks. Because the bailiffs would, if the landlord got into court the day the possession order takes effect and issued a bailiff's application, and then the court acted quite fast, you'd probably be looking at 2 to 4 weeks before bailiffs came. And so, but the problem is you don't know how quick the landlord's going to be. If it's a local authority, they could take weeks. It's sitting on somebody's desks. We got a possession order, you've got to fill in this other form to get the bailiffs instructed, and they don't do it. But don't assume that. But then again, don't assume that just because you don't hear anything, nothing's going to happen, because they've got, I've forgotten how long it is before they can't, I mean, it could be 6, is it 6 years? I'm not sure. Maybe it's less time than that, but it probably won't go away if they've got a possession order. So you need to either apply to suspend the warrant, which you can do if it was made on discretionary grounds, or apply to set aside the possession order and stop the eviction that way. So that's the end of that.
No, that's cool. So citizens advice bureaus kind of do vary quite a lot depending on who what personnel they've got there, because sometimes you have different specialisms. But would most citizen advice bureaus have kind of a court desk type person who would be familiar with this process in your experience? So I'm just thinking that if I haven't just taken in what you just said. I just wonder if someone's in this situation, is there like a reliable service which covers a lot of the country which they could access? Because again, lots of services will only cover certain areas, but I think most areas have a citizens advice bureau, if I understand it correctly.
Yeah.
And it seems to be that this is the sort of thing they are likely to have expertise in. But I don't know. Maybe people in the chat, if you've had experience of CAB or another organisation that helps with this sort of thing, it might be good to share actually just about that.
My advice would be that the CAB isn't necessarily going to have one in every place. When you occasionally get people at the CAB who are absolutely first rate, and I wouldn't want to just put that down, but I wouldn't assume that you'd get an appointment at the CAB or you get somebody. I've heard terrible things about people being advised things like go home and pray and stuff. So what I would suggest you do, though, is that most of the county courts will have a duty housing scheme, which you just mentioned. And if you go down to the court, and the horrible thing about the county courts is the only people you're probably going to meet who work for the court are the security staff. And they're particularly, as you can imagine, they don't like giving out advice. They're not supposed to give legal advice. But you could ask them, can you tell me when or you could ask the ushers at court, when's the duty desk? Because they normally have a possession day when they deal with all the possession claims. And that's the day that the duty advisor will be there. And if you go in there and you haven't got a hearing that day, they'll probably still try and help you, if only to say, come back on another day and we can try and sort you out or refer you somewhere where you will get help. So the county court is your best destination, even though when you get there, you might find a sort of rundown building that looks like prison staff at the door. It's not very welcoming, but just ask them to tell you when the possession day is. They should at least be able to tell you that.
Yeah, cool. That's useful. And someone just put in there saying with Shelter and CAB, you can ring them and kind of get some info.
Yeah.
Fill a form in
Sorry, I forgot that. Good point.
And I'm just wondering also about, so in this situation, it depends on the timing, but making a homeless application, again, certain councils have a particular worker who's assigned to defending possessions effectively, or kind of trying to stop people become homeless, because that's what the prevention duty is supposed to be about, is actually seeing if you can wriggle out of the eviction in one way or another, or extending it or whatever. So again, although we obviously sound like we're very critical of housing officers, there are lots of good housing officers around, and some of the in this situation they are motivated to help out. They are, if they can stop you becoming homeless, then that's one less person they need to deal with when you do become homeless. So they can be very informative, if nothing else. Next question. Someone currently living in a YMCA hostel. They'd like to move into a studio flat but don't have any money for deposit. Is there any help available? This is potentially, this is going to depend on your area, and it's also going to depend on your age, because YMCAs traditionally were kind of for young people, but actually I think the YMCAs YMCAs in Bedford, they're not even called that anymore, but they like any age. So now I can only go on what the organisations I've worked with. Most organisations will have a move on policy, which you should be able to you should be given, really. If you're working at, if you're living in a supported accommodation provider, they should be able to freely give you stuff. You should be seeing a support worker every week or whatever, and you should be able to say to them, look, what's the move on policy? And lots of YMCAs or other similar organisations will have a structure where if you stay there for 6 months without getting into trouble, they will give you a particular banding on the housing register, which in Bedford is band B, I think. You get band B if you have done X number of months, and I think it is 6, but people do tend to take longer. So, and that's the route into social housing. I often criticise supported housing, and I'm not sorry for doing so. One of the things they do is they create a lot of intentionally homeless people because their rules are so strict. Another thing they do is they lock you into that process. They don't tell you this when you move in, like, oh yeah, by the way, you can't make a homeless application now because legally you're not homeless anymore. So one of the things you can't do in that situation is to apply to the council's like homeless team, whatever, because you're not legally homeless unless you were to get evicted, which you don't want to do because you'll be intentionally homeless. So my first point of call would be to ask the organisation for their policy and ask them specifically how long do I need to be here before you guys refer me on and get me on the housing register. Well, obviously, once you're on the housing register, you're still going to have to wait some time. So you're going to be looking at potentially a couple of years by the time you actually move out in some situations. But I would say that's not, you know, if you're in that situation, that's the best you're going to hope for. You know, that technically speaking, you could go, well, so technically you could go to housing options and say, have you got any private rented accommodation going spare sort of thing, or do you know any landlords? And there's an absolute outside chance, it's technically possible, that they might say, yeah, we've got something today and we can't fill it. You know, are you a decent tenant? If you look like a decent tenant, we'll refer you to the rent deposit scheme. But I would say there's about a 0.01% chance of that ever coming to fruition. Just kind of, you just have to get very lucky. So I don't know what else someone in that situation can really do in terms of other than just do their time. I mean, I guess another option might be to, if you don't like your current accommodation, you might be able to apply to a different support accommodation provider, because lots of people just do the rounds. They just go from one place to one place to one place, which again is not ideal, but it's possible in terms of improving your options or increasing your options. So yeah, I don't know what in terms of that YMCA questions, anyone else got anything to add to that?
I mean, it's not an ideal route, and I know the threshold and the argument is quite high. If it was unsuitable because it was affecting, say, your mental health or your health in general, or for whatever reason, and yeah, a lot of supported accommodation is unsuitable for people for a number of reasons. You could make a homeless application because you'd be homeless because it's unreasonable to continue to occupy. If you were to go down that route, I mean, you'd want an advocate, you'd want support and letters, you'd want evidence, you'd want the full hog before you even sort of started going down that route.
Yeah, I mean, the YMCA is a relatively reputable organisation, so we've done that argument before with these really kind of cowboy organisations, these kind of, you know, these rogue landlord type support accommodation providers. But I would hope that the YMCA is not offering support so bad that it's making you worse. But Shannon says, you know, actually support accommodation is definitely not for everyone. So technically you can make that argument as well, but you're going to need a consultant, psychiatrist letter probably, or a consultant something saying, you know, saying why it's clearly unreasonable for you to continue to live there. Yeah, so someone just saying there, most cities have a housing drop-in centres and look on local council sites, and is always a good idea. Yeah, I mean, one thing big cities do have is lots of services for homeless people. You know, it's quite marked how different it is in a smaller town or something compared to the big cities, how many services are actually available. I mean, for obvious reasons. But obviously you've got the highest chance of getting housed quickly in those kind of rural areas. So yeah, this kind of certainly swings and roundabouts with it. I don't think there's any more. There's some comments in there, which are cool. Bit of conversation going on. Yeah, so yeah, that's an interesting one. That's got my heckles raised. So some housing officer advised me to go on the street and call StreetLink. I dislike StreetLink intently. StreetLink is an organisation where members of the public can ring in and say, I've seen Joe Bloggs, he's got a big beard and he looks homeless, can you go help him out? And that goes to the councils or the you know, a street outreach team somewhere who might eventually get around to verifying you and helping you out. But that process is problematic. It again then depends on the area you're in. Some areas, once you have been verified, do have good support available for people sleeping rough. But the idea that your advice is to go and sleep rough is a pretty damning kind of damning system that you're working within, where that's the best thing you can do. And Shannon did a real good post a few weeks ago on our social media about essentially why verification is problematic. It's certainly not legal, because councils have to take homeless application, not tell you to go and sleep rough. But anyway, so yeah, just the person in the YMCA again saying they don't want to help me for some reason. I was thinking about private housing, so I don't want to wait ages. You know, private housing, if you can get, I think the only way would be is for you to raise the funds, and you've then got the problem that you need to find a private landlord who's going to take you. And you know, they're very kind of discriminating. Sometimes they won't, if they don't like the look of you and you're not working and so on, then potentially they won't take you unless you're going to settle for really kind of poor quality private rented. And having worked in supported accommodation for many years, I'd say it doesn't surprise me at all. Staff are not fair. They don't treat people fairly. They don't kind of do things objectively. They will have their favourites. If you ask questions or complain, they will not like you and they will try to find reasons to cause you problems. So that's my experience anyway of various hostels.
I mean, potentially though, if it's, you know, if you're willing to go down private route and you think you can afford it financially every month for that one-off payment, I mean, so universal credit, if you're on universal credit, obviously they have emergency loans and whatnot. So often the DWP can be quite good if you explain, this is my plan, can I have help with this? And likewise, I do wonder if you approached the council and said, look, I'm not going to make a homelessness application, could I apply for a discretionary housing payment in order to help me get, you know, private rented? That might be another sort of route.
There's always a chance you deal with a good housing officer. We're not going to, you know, sort of say that. There are housing officers who will bend over backwards to try and help you out. But that's probably not that's the exception rather than the norm. Okay, so we had some pre-arranged questions, guys. Is there anything you want to cover? I mean, if you guys have got time, I did want to talk about something which come up, which I think actually your question that we talked about before might also fit in with. So if that's okay, if you guys got
stick around for a bit.
So last Thursday, I was delivering training in Taunton and I got 2 calls within minutes of each other from different parts of the country. So one was in Surrey and one was somewhere else, I can't remember. And basically, they're both domestic abuse charity workers. And their question was, well, what they essentially said was almost identical. They said, my client's been advised that if they make a homeless application, they're going to drop down the banding on the housing register. You know, in one sense, they're already like band A or band 1 because of the domestic abuse, and they've made a Part 6 application. But if they make a homeless application, they're going to be penalised, and they're going to end up with a lower banding. And if you'd asked me that a few months ago, I'd have said, oh, that's not possible. That's not that, you know, housing allocation schemes don't work like that. But we talked a few months ago about Buckinghamshire, where you could be band A because of medical needs. You know, you're home, you know, you're at home, you've got serious medical needs, it's not suitable, so you're band A. Then they're so unsuitable that, you know, you can't live there any longer, so you make a homeless application and you immediately drop down to band E. And then once the main duty is accepted, you only go up to band D, so you're considerably worse off than you would have been if you'd stayed put. Now with domestic abuse, it gets more interesting, if that's the right word, because in theory you shouldn't be on Part 6 if you're experiencing domestic abuse, because the council should have treated your application for housing as a homeless application. That's what the Code of Guidance says. There's a bit of obscure case law. You can say, well, if you expressly say you want your application to remain as Part 6, then okay. But there seem to be a number of areas where in that situation, you know, you're at high banding because you're deemed to be at high risk of domestic abuse. As I say, you should therefore be under Part 7, but anyway. But then if you make the homeless application because you just can't bear the abuse any longer, you immediately drop down several bandings and you end up at, you know, band 3, band 4, whatever. And I was like staggered by this because I thought that can't be possible, that's the way it's working, but that does appear to be not just a one-off. And the question you had, Will, just about, you know, what your client was told, I was going to bring up the wording just so I don't mess it up. So yeah, essentially, you know, in that situation, they've been told that, you know, if they make a homeless application, then they're going to drop down because they're no longer homeless, if I'm reading that right. And as we said, that's definitely not legal. But I think that this issue of different housing allocation schemes penalising people for making applications appears to be pretty widespread. And as I say, like, you know, that it shouldn't ever happen, because if you're experiencing significant domestic abuse, you should be whisked away from that and offered something suitable straight away in terms of temporary accommodation. You should not be left there, and you should not be incentivized to remain in that property subject to abuse, you know, because it keeps your banding high. That just seems to be something which is outrageous. And if I was in those areas, I'd be immediately getting onto the council, going to the housing committees and saying, do you realise what your own housing policy is doing? Because it's not okay. But yeah, that was more of a rant than a question, really. I did have some questions around it, but I guess part of my question is, are other people seeing that kind of system where you're penalised for making a homeless application rather than just staying on the housing register under Part 6? And I guess it's something that we probably want to start gathering evidence on when we're doing our training around the place, because if it is widespread, it might be we can come up with some template questions you can throw to the local housing committee to get them thinking about it. I mean, fortunately in Bedford, our housing allocation scheme is pretty fair, to be honest. It's pretty good policy. But yeah, I mean, Will, in terms of the kind of the question you had or the situation you were dealing with, do you want to kind of talk about that? Because I guess it does fit in a little bit with it.
Well, the text that I sent you earlier was an extract from an email message which I was sent, which was quoting a social worker. Sorry, it was a social worker quoting a housing officer. So there may be a little bit of something lost in translation there. But what they'd said was that there's a if the client went into temporary accommodation, they would drop down to a lower band. They'd go from they're currently in band B, and if they went into temporary, they would go in. They'd no longer, they'd be. She would lose band B and be placed in C1 to C2. And the thing that struck me was a sinister wording, where it's saying that there is a priority banding, which means that Ms. X must maintain preventing her own homelessness to keep this banding, which is pretty worrying if the cause of your homelessness is domestic abuse, because the implication of that is you've got to continue putting yourself at risk of domestic abuse or experiencing domestic abuse in order to prevent your own homelessness, or prevent people from recognizing your homelessness would be a better way to put it. So something's definitely wrong there in policy terms. I can see where it comes from, because it goes back sort of 10 or 15 years ago when people looked at the spreadsheets and said, hang on a minute, the only way to get a council flat in this country now is to apply as homeless. And for people who are waiting there was this idea of a sort of young family that were waiting patiently, staying with their own, like 1955 or something, staying with their in-laws. And they people jumping the queue, and maybe people coming out of prison or people who were considered undeserving. So it led to this idea we've got to sort of ring fence the social housing and sort of penalise homeless people. And this kind of thing is I mean, it's tricky, isn't it? Because it's like this same problem I was talking about earlier. There simply isn't enough accommodation for everyone, and it is a bit hard if you're in a council place and you're waiting for a transfer because you're disabled or something, and you get told, oh, sorry, somebody's jumped ahead of you because they were deemed homeless, and you'd have to then be homeless and go into temporary or something. So, but I think something needs to be sorted out, that people shouldn't be told that they need to maintain preventing their own homelessness when it's not their choice.
I mean, it sounds to me like the kernel of that statement, there might well be truth in it, in terms of you lose priority if you go into temporary accommodation. That seems to be, as I say, plausible. I mean, just on this, this kind of, because we've had arguments with Bedford Borough Council before about this, and my argument has been you've got three categories of people on the housing register. You've got management transfer people, transfer applicants, people who applied directly to Part 6, and then homeless applicants. Now, the example he gave to someone who's waiting for a management transfer because of a disability, they should be deemed to be homeless already. They should, I don't see why they're not, and they could remain homeless at home and kind of, wait. But the whole point of the homelessness provision is that it's identifying people who are in the most urgent need. And so in one sense, if you've got a low level transfer kind of need, then you should be trumped by people who are fleeing domestic abuse and have made a homeless application. But on that same kind of thing, like, so we've done training this week with a domestic abuse organisation, and so it provides refuge accommodation, and their licence agreement is interesting for a number of reasons. One is that it specifically says it's Part 7 temporary accommodation, and I don't think they know that. I don't think they realise that. But secondly, it kind of has these explicit kind of statements around you must engage with the support that's available, and the situation could arise where, because you don't engage, you could be evicted, and because it's actually Part 7 temporary accommodation, although no one seems to know that, they could be, kind of end up with an intentional decision down the line because they're seen to have kind of, acted in a way that led to them becoming homeless. So, yeah, it just seems to me like there's this is an issue which might be more widespread than certainly that I was aware of, where you've got, these kind of these policies that are in place which just aren't how it's supposed to be. As you say, it's never about who's deserving. It's about apply the policy. That's, apply the rules. That's the way the housing law should work. It shouldn't be housing officers taking a liking or a disliking to a particular person and treating them better or worse for it. That certainly happens. Certainly, in my experience of working with the local authority, that would definitely happen a lot. Okay, yeah, as I say, I think that's just something that I'd like to return to in future weeks. Just kind of have a think about as we go forward. But has anyone got any other kind of burning questions? I'll just throw it out there to the people watching. If you've got any burning questions, now's your last chance. I'll give you 30 seconds because of the time delay. But Will and Shannon, have we got anything else we want to talk about this week that Denise dealing with?
Can I just answer one point on the chat? There's a question, how can we find a solicitor with any website or address? The answer to that is it's very difficult because, as you may know, solicitors doing legal aid housing work have been sort of dropping out of doing it because of they haven't increased the rates of pay for 20 years and various other things. But I have drawn up a list of solicitors, and I'm not wishing to plug my website or blog, but if you search for William Flack blog and you go to that blog and you go to the resources section on there, there's a set of resources and one of them is a list of solicitors. Unfortunately, they're in London, but don't worry too much because solicitors in London can, in theory, help people outside London, and that would give you all the contact details. And if there's anyone looking at that who sees the list and says, oh, I know there's other solicitors, please let me know.
You're allowed to plug that, Will. It's fine, mate. Yeah, cool. Yeah, it's a really good resource. And again, it might be worth something we come back to later in how you approach solicitors firms, because again, they're busy, they're at capacity. How do you present your case in a way which they kind of bite and actually want to help you out with? So, okay, there's no more questions coming through. So thanks very much, guys. If you haven't already, do like and subscribe to the channel, like the video, blah, blah, blah. We'll be back next Thursday, I believe. I think Shannon's on her travels, but I think, Will, are you around next week?
I'm around next week, yeah.
Yeah, cool. So there'll be at least two of us. Keep the questions coming on YouTube. Do check out our training. So the October date, the introduction to training, homelessness law training online is pretty much booked up now. We've had about 10 places go in the last 2 days. So the next date after that is the 17th of November. And do keep your eyes peeled for the ethics of gatekeeping event. We're doing it in a couple of, 2 months or so, just less than 2 months. So, but yeah, cool. Thanks, Shannon and Will. Appreciate your time. Thanks everyone for your questions and just the lively discussion that's going on. That's really cool. We'll hopefully see you next week.
Bye.